right, thank you very much for coming. I'm going to do a presentation on copyright and photographs, photography. I'm Larissa Pastuhiv. This is my colleague Alicia Machek. We're from the Copyright Office, and we're going to talk specifically about photographs because there are a lot of misconceptions about copyright and photography. So we're going to just touch on a couple of the major issues. We'll take a very brief glance at the history of photography, the copyright protection of photography. One of the major issues that causes problems may sound very simple, but it is actually determining who the author and copyright claimant is of a particular photograph. And I'll explain more about that in a minute. We'll talk about how copyright registration can help when you're trying to get permission to use photographs, and certain highlights in various issues. So visual arts, the visual arts division of the Copyright Office deals with a wide variety of artwork, drawings, paintings, graphic art, illustrated books, textiles, meaning floor coverings, wallpaper, bed sheets, jewelry, toys, maps, technical drawings, architectural works, and architectural works means both the blueprints as well as the buildings themselves, the structures. The copyright registration, when we look at material to register it or not, we don't look at, it's not affected by style or form. It can be representational, abstract, naturalistic, or stylized. We don't consider artistic merit or aesthetic value or commercial value. We're really just looking at what the artwork is and the original authorship involved. So we get a lot of works that are collaborative authorship. You have joint authors, like comic books or graphic novels, websites, illustrated children's books or any kinds of illustrated books, and genealogies. And we're going to look again at genealogies specifically because a lot of them deal with photographs, specifically old photographs, which are problematic. So when we talk about copyright protection of photographs, we're looking at how an author captures an image. It can be a sports photograph, an artistic photograph documenting a particular event or a historic moment, advertising photographs. They can be professional, they can be snapshots, published or unpublished. So let me just take a quick historic look at photographs. Copyright protection of photographs goes back to a time in history when photography was very different from what it is today. The bottom image, you can see the fellow with the drape over the camera, familiar to all of us. There was a real science to it. Most of the photographers of that day had their own darkroom. They mixed the chemicals. There was a lot of art form. There was a lot of technical skill involved in creating photographs. There's less so today in many respects, although we have Photoshop and things like that. But it's different. So back in those days, the Copyright Act of 1870 had a section that specifically mentions photographs and that it's considered an artwork. And I'd like to bring to mind Matthew Brady's photographs, which we are all familiar with, a marvelous American historic photographer whose images actually made their way to our currency and postage stamps. So photography has a rather venerable past in terms of copyright protection. In 1884, the copyright protection of photographs was challenged by an infringement case of this portrait of Oscar Wilde, which was photographed by Napoleon Cerrone. And Giles Lithographic Company challenged the copyright protection using the image and saying that photographs don't qualify as the writings of an author, and in fact they refer to them as technical prints, technical products, which is interesting to consider for us as we know photography to be today. But even today we do recognize copyright protection of photographs. So let's take a look at the genealogical works and photographs in genealogical works. The issue when you're dealing with photographs, we get an awful lot of copyright applications for genealogical works submitted by genealogists saying that they're the author of the entire work. And they'll say text and photographs. What's wrong with that picture? The photographs are usually of their ancestors. They identify them as photographs of their ancestors. So they didn't take the photographs, and it's not their photograph. Now, they can own the physical copy. A lot of times they will have inherited the photographs through the lineage from their ancestors, but they're still not the photographer. And oftentimes, like we were looking at before, in the 18th century, in even the early 19th century, you didn't have photographs unless you went to a professional photographer, to a professional studio. So who's taking the photograph? It's not the subject, it's not those ancestors that are pictured in the photograph, it's the photographer, the photographic studio who took them. Sometimes they will be stamped on the back of the photograph, oftentimes they won't, but that doesn't help you in terms of the Copyright Office, in terms of saying, oh gee, if you don't know who it is, then it's okay. You still have to know, and you still have to track it down, or at least on the application form, exclude those old photographs and say that those are pre-existing, created by someone else. So when we look at who the author is, the author of a photograph is the photographer, not the subject of a photograph, nor the owner of the photographic print. People somehow misunderstand this point. It's very clear when you're dealing with a book. If you own the book, you don't acquire the copyrights. But with photographs, people somehow miss that point. They think that they own the prints, they own the negatives, and so don't they own the copyrights? If you inherit photographs, you acquire the physical copies of the photographs, but not necessarily the copyrights. That means that you own the physical copy, which may have commercial value, may have historic value, but it doesn't give you the right to claim copyright on it or to reproduce it, to duplicate it. Copyright ownership is distinct from ownership of the physical copy. That's section 202 of the copyright law. The copyright is a property right, but it's not necessarily packaged with ownership of the physical copy. It's two separate things. The transfer of ownership of the object does not automatically transfer the copyrights, and vice versa. Transfer of the copyrights does not necessarily convey property rights of the object. Is everyone following me? Do you have any questions? Okay, great. Yes.
I have a question. How does this work in terms of when an institution like a library or an archive owns old photos that they clearly did not create, but yet they're charging users to reproduce the image because they claim they own this photo? I mean, please repeat the question.
Yeah, the question is, how does actually?
Why don't you say the question?
Okay. All right. So often it's the case that a library or an archive has ownership of a large number of old photographs that they clearly did not create. And they are now saying that because they own the photo, that unless people pay them money in order to reuse the image, that they will be upset and that the people will not be allowed to use the images without paying them something. And I'm wondering, because clearly they are not the author of the photo, how that works, especially when a lot of these images are so old that any copyright that once covered them has now long expired.
Good question. The answer isn't always that clear. There are a number of different factors that can enter into this. When you're talking about a library or an archive that owns the photographs, they have a number of policies that they cobble together, that they adhere to for users, which may or may not serve users in the way that users would like. Sometimes it may seem as if it's a stumbling block and just makes things more complicated. But what they are trying to do is they have acquired the rights to the photograph. Let's take the scenario, I mean, it's a big answer, but let's take the scenario that the photograph is public domain. There's no copyright. So it's not a copyright issue, but they're charging you money. Likewise with paintings, like in a gallery. If you go to certain museums or galleries, they'll either forbid photography, or if you photograph, if you have an agreement to photograph their works, they'll charge you a fee. So how is that right if there's no copyright protection for the material? Well, that's really a scenario that functions outside of copyright, because they do own the physical copy, and it's a one-of-a-kind copy, and they're responsible for housing the copy, for preserving the copy, for the temperature control, all of those things that are taking care of that copy. And so the fees being charged really are more of a housekeeping thing rather than copyright. Now, if it deals with copyright, then there may be an agreement that they have with heirs of the photographer, possibly, that they'll take your fees and then siphon them off and relay them to the heirs, that sort of thing. Yes, ma'am.
If somebody goes to a photographer for a portrait, if somebody goes to a photographer for a picture, to have their picture taken, isn't that something that could be considered a work for hire?
It can be. Yes, it can be. And if it is, if there is a work made for hire situation, if you sign an agreement, then you do walk away with the rights. You'll probably pay more for the photographs. Likewise with like weddings or graduations. If you hire a photographer to do photographs for you, there's usually a contract. In that contract, it'll say whether you own the rights. I mean, there are different kinds of scenarios there too. It's not a clear case, but you can hire a photographer just to do a job for you, and they retain the negatives. You then order from that photographer for prints from the negatives, or you can hire a photographer and they hand the whole package over to you. Then it's up to you. And then the agreement will say that you're the copyright owner in a work for hire situation like that. But usually what I'm trying to address is that it's not a simple transaction, and these are great questions to highlight that. And a lot of times people aren't even aware that there are those distinctions. So another question that we get a lot of is, can I use a photograph if it has no copyright notice? Well, the copyright notice is not a legal requirement under the current law since 1978, but it was required before 1978, but only for published works. It wasn't required for unpublished works. So if you're asking the question about a work from before 1978, hey, you know, there was that strict requirement, and here I have a photograph and there's no notice on it, so is it free and clear? Well, do you know for a fact that it was never published? Or, I mean, the copy that you have may not be the published copy, unless it was like a postcard. You may have a print which was published in a periodical. There may not be a separate copyright notice on that photograph, but if the periodical has a copyright notice, then it's considered published with a notice. So there are a lot of caveats to it. It's not clear cut that you can say, oh, this is from before 78 and there's no notice, so it's free and clear. We get a lot of questions, we get a lot of submissions for copyright protection in photo restoration. There's a lot of skill involved and technical knowledge in making digital editing that allows enhancement, color adjustment, photo crispness. I mean, you can see the before and after, the two examples on the bottom. Obviously, someone very skilled worked on those photographs to restore them to the way they were originally. But the key is that you're talking about restoring to the original. You're not actually creating a new work of your own. You're trying to restore what the original photographer made. And so we can't give copyright registration for a claim to authorship in that restoration situation. There are times, outside of the box when there has been work done in addition to just restoration, where it's possible to copyright it. But these basic examples of restoration don't qualify. So, if you have a work that you would like to use and you're wondering, how do I get permission, you probably would be well served to take a look at researching the copyright registration records. And the records for all registrations from 1978 onward are online on our website at copyright.gov. Before 1978, it's a manual card catalog. You can order a search to be done for you. But the information that you would need to know, the issue with photographs is that there very often is not a title, the way there is for books and music. Very often you don't even know, you can guess who the author is, who the photographer is, but a lot of times if it's an older photograph, the company's gone out of business or the photographer is deceased. I'm not saying that it's easy. I'm just pointing out that the registration records can be helpful. You would need to know the year of first publication if it's a published work. If you can determine that it's published, that'll really help you. Because before 1978, it would have to be renewed in the 28th year from first publication. If it wasn't, then it goes in the public domain. And that will give you if it is protected, then you can find out the name and address of the copyright claimant, the person who you would write to get permission. So I wanted to highlight a very talented street photographer, Vivian Meyer. She actually lived here in Chicago. You may know about her because actually she's been mentioned in the press a number of times. She's the late Vivian Mayer, but she, as many very talented creative artists are, she was rather eccentric. She created voluminous files of street photography. She used all of her free time to do this. She made beautiful works and kept them locked in a drawer. She never published any of them. And they came to light in an auction. An art collector purchased them in the auction, took a look at the negatives and recognized their value. The issue is that he filed a claim to copyright for the photographs, and I think you can guess, our question was, how are you related to the deceased photographer? He said, I'm not, I just own the negatives. So we had a problem with that. He went on to, Mr. Maloof, went on to create I think more than one book about this street photographer, as well as a film. Now, the documentary, clearly, he owns the rights to because he created the documentary. The book, he owns the rights to whatever he created, minus the photographs that were not his. And here you can see the clear distinction. He purchased and acquired the negatives, which he owns, which are valuable, but he doesn't own the copyrights to the images. I wanted to point out this photograph that came in for copyright registration. This is obviously a well-known historic event. This was taken by a spectator with her cell phone. And it came into the Copyright Office with a dual authorship listing the woman who took the snapshot and the FBI. And the FBI was listed because they enhanced the photograph, bringing out details, because on the cell phone shot, the original cell phone shot was not very clear. And they originally sent both images for 2 registrations. We had to reject the first one, the raw cell phone image, because this one was clearly superior. But this was a very significant photograph because it was going to be used in the court case to show where the people were and what was happening at that time. So going back to the beginning of this presentation, when we talked about the photographers in their studios with the hoods over the cameras, we've come a very long way, and photography is something that is available to virtually everyone today through today's technology, and it doesn't have to be a beautiful artistic image to have value. This is an example of that.
Can I ask a question?
Yes.
Just in this example, there's the man running.
I'm sorry?
You know, the gentleman who's running. Sorry. So, question about if a subject of a photograph can claim copyright. So in this instance, that man that's running, if he had the photographer, the one with the cell phone, could she sign away her rights to him and have him say, "Oh, this is a photo of me. I'm copywriting this picture of me." Can he do that? Because he clearly didn't take the picture of himself. She did on the cell phone.
No, right.
Sorry about the feedback on the mic, Tim.
Okay, so the question is, could the runner claim copyright? That's what you're asking, right? Could the photographer sign the rights over to the runner?
Yeah, like he wants, he says, "This is the picture of me, so I want to claim a copyright of a picture of me in this historic event And the one with the cell phone, if she said, "Oh, I don't care about that. Go ahead, you can do that." Would you allow him to do that?
In this particular case, the woman signed over all of the proceeds from the photograph to go to the families of the injured people. As for the subject, I mean, she could sign over the rights to him, yes, but if the runner were to object to the use of the photograph, that really would be a privacy issue, not a copyright issue, because the privacy laws are what prohibit widespread distribution of the image of an individual. I mean, you have all of the people in the background, but that really is a background shot. You're right that he stands out because he's really the only star of the photograph. But that's a privacy issue. That's really not it would only be a copyright issue if he negotiated with the photographer to acquire the rights to this image. Yeah, if she signed over the rights to him, then yes, he could file a claim to copyright. He would still list the photographer as the author, but he could list himself as the owner of copyrights by assignment from the photographer. So this photograph came in as there was an issue in the authorship, in the way the author was listed. The dates of birth and death made it suspect that they were actually giving us the correct photographer. And it turned out that the applicant was the woman in the peach-colored gown. And she said, "Well, no, of course I'm not the photographer. I'm in the photograph. My mother is the photographer." So we wrote to her and said, "Okay, well, if your mother is the photographer, then we need to change that space that you gave us listing yourself." And she said, "Well, but you can't list her because she's deceased." Well, you can list a deceased author. The authorship statement is a statement of fact. It's who created the work. Her mother created the work. She, in fact, the woman in the peach dress did in fact legally own the rights of copyright because she inherited the rights from her deceased mother. But this was an interesting case because shortly after she filed the application, during the course of the correspondence, she said, "Well, I really need to have this registration quickly because Time Magazine is going to be publishing it." This is the image that was actually published. Some of you might recognize it. But it also allows me to point out one last point, which is that copyright protection, the effective date of copyright protection is when you create the work, and the effective date of registration is when we receive it, not when you get the certificate. So there really wasn't that deadline. She was just a little nervous about it. Okay, so the point that I just made, copyright protection is automatic from the time it's created, and it's considered created when it's fixed in a tangible form. The registration makes a public record of the claim, including the contact information for getting permission. Registration within 5 years of the first publication ensures that you're eligible for prima facie evidence of the facts given on the registration, which is very helpful if you're in a court case. You don't have to go through proving each factual piece of information. And you're then eligible for statutory damages and attorney's fees if you have that registration within 3 months. Okay, so thank you very much. Yes?
Copyright is when it's fixed, so we have digital objects that, are they fixed? So when you take a picture with your digital camera, is the copyright then, or does it have to be printed?
We usually deal with a physical copy, and the sensibility about when it is fixed in tangible form is changing clearly because we living in the digital age. But the fact that it's retrievable doesn't necessarily make it fixed in tangible form. Just like in the old world, when you had that negative, does that make the photograph fixed in tangible form? There's still one more step from the negative to the print. So it's less of a step in today's world, but we consider it fixed in a tangible form when you print it out. When you print it out, I mean, you can tell us that you print it out from the time the photograph is saved in your camera. I mean, we'll accept that. We're not going to challenge it, but if it ever came up in a court case, the distinction would be when a copy was made available. Absolutely.